Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. Hope everybody's having a fantastic spring. It's been a little bit windy, but beautiful nonetheless. We are slogging our way. I think slogging is the right word for this. Slogging our way through yet another edition of the 2022 New Contract Series changes. I think this is number 7 in the lineage of changes, and we're getting to the end, kids. We're very, very close. I think I'm going to do one more after this one that's going to address the 2022 contracts update and the changes that we've made. Obviously, there were tons of changes, but I'm trying to hit the ones where I've had repeat or recurring questions on the legal hotline related to things. And this one I'm going to do today is probably number 1 or 2 in terms of questions or confusion that I've seen from the Colorado Realtor community out there and have seen questions on the hotline with. And that is the changes that were made in the contract related to association assessments and how those are paid for. There's 2 primary areas that I think are causing a little bit of confusion between the 2 of them. One is under what is 15.3.3. Now, remember, under paragraph 15 generally is talking about status letter issues, right? And things that might come up in the status letter when that's received. And 15.3.3 is entitled Assessments, Reserves, or Working Capital. All right? And that would be something that would be notated on the status letter when it's received. It says, you know, hey, in order to come into this association, the money has to be put onto deposit or escrowed with the association, because a lot of associations have a mandatory level of working capital or reserves they have to maintain. And typically, when a buyer comes in, they bring that money in and put it on deposit so that the association that they're purchasing a property in can maintain compliance with its bylaws or rules and whatever those may be related to maintaining escrowed working capital reserve funds in case something really goes wrong with the property, right? So those are the kinds of things that we're talking about in 15.3.3, assessments, reserves, or working capital. And unfortunately, there's this language that speaks to assessments that are paid in advance. All right, that has created some confusion now because there's check boxes there in that section 15.3.3 that allow a buyer when they're making an offer or a seller when they're countering an offer to address who is going to pay for these assessments, reserves, or working capital. And in some situations, I think primarily out of confusion, a buyer is checking a box, seller is going to pay for that. Well, I don't think typically that is how that should be working in most transactions, unless it's, you know, commonly negotiated or negotiated by both parties with an understanding of that's what's actually going on. But there's some confusion related to what that exactly means. And so I'm going to come back to that in a second. But the confusion also, or in order to clear up the confusion, I need to address paragraph 16.2. Now, this is just down further on the same page, but this speaks to what are really regular or special assessments that are paid in advance as well. But 16.2 have to do with what I would say are most commonly referred to as association dues, regular assessments, or special assessments, which does have a check box involved there. And so a lot of people, and including even some title companies that have been trying to work through settlements, have been conflating the 15.3.3 stuff with the 16.2 stuff. Now, 15.3.3, who should be paying this? In my view, in most cases, unless it's freely negotiated with the seller's full understanding, that ought to be paid by the buyer. Because again, these are deposits or escrowed funds, working capital, reserve fees, assessments that are paid in advance that are essentially held in escrow by the association and to maintain a fund that is available for the association to tap into in the event that there's some catastrophe or there's some big project that comes up that the association needs to take care of. And so those funds are really being paid or should be paid by a buyer who is buying into the association. Presumably when the seller bought into the association, they had to pay their own set of funds, the same amount theoretically, to get in and have their own working capital and reserves on deposit for the same thing. So when they get out, Sometimes the associations will, per the association rules or bylaws, return those funds back to the seller now, and they will collect those funds then from the buyer when the buyer comes in. Not all of them do that. Some of them keep the funds and they just keep building in their reserves or working capital, but that's really up to the individual association. For the purposes of a new contract, though, if you're representing a seller and it's in a community association, you really need to be paying attention to that 15.3.3 box. If a buyer has either intentionally or erroneously checked that seller will pay, what that essentially is meaning is that your seller, when they go to sell the house, is probably going to be essentially double paying into this association reserve fund, or they're going to be losing their opportunity to have the credit that they have with the association essentially returned to them when they close, right? And so you've got to be careful and not screw this up. If you do, there's a chance that, again, your seller is either not going to receive a return of their money back, or they're going to have to actually cut an additional check to the association to pay for the buyer's input into the buyer's working capital and reserves fund, okay? So it's an important thing not to miss, and I think we've had some situations where that confusion has led to some frustrated sellers over the last several months. The other thing I want to point out is 16.2. By default, without any checkbox in paragraph 16.2, the seller gets a credit back for any association dues or assessments that were paid in advance. So let's imagine a scenario where an association collects their funds or association dues quarterly. And on January 1, the buyer pays $1,000, just to use a round number, for their first quarter assessment. And then on February 15th, you have closing, right? So what would happen there per the terms of the contract is the seller paid in $1,000 at the very beginning of January for the first quarter. They should receive then, by the terms of the contract itself, without any negotiation or checkbox, the seller should receive a credit back from buyer for $500 in my example there, because it was $1,000 paid in for the entire first quarter. They close on February 15, which is halfway through the first quarter. Seller gets a credit back of $500 for the portion that they have paid essentially on behalf of buyer from the point of closing through the end of the first quarter. That's by default. It happens naturally. And then, of course, also in 16.2 is the assessments or special assessments that occur after contract or at any point in time prior to closing. And that is a negotiated point. Buyer pays or seller pays. I think, again, in most cases, what's most common is that the seller ends up paying any special assessments that occur prior to closing, even if those improvements haven't actually been made yet. And so that's the 16.2 stuff. But again, don't conflate that with 15.3.3 because in most cases, I believe the appropriate thing there would be for a buyer to be paying and bringing that money as they buy into the association to deal with those assessments paid in advance, working capital, reserves, whatever that individual association may call it. That should be on the buyer. So don't miss that if you're a listing broker in receiving an offer. You're going to want to probably counter that out on behalf of your seller and switch that box over to the buyer who's going to pay that. If you have questions about this, any other changes in the contract, or anything else, Car Legal Hotline's available from 9 to 12 and 1 to 4 Monday through Friday. We'll talk to you there, and we will see you again on another edition of Legal Bites. Take care.